to continue the trial on People v. Rapson. And Mr. Rapson, have you had a chance over lunch break to talk with your lawyer about whether to testify or not?
Yes, I have.
Okay, you remember I went over with you your constitutional rights to testify or not testify?
Yes,
And he gives you some advice, but it's your choice.
yes,
Okay, if you choose not to testify, I'll tell the jury they can't use your silence against you, but you also do have the right to testify. Do you understand all those rights?
yes,
Do you have any questions for me or for your lawyer about any of those rights?
no,
And have you had a chance to make a decision?
yes, I have.
And what is your decision, sir?
I'd like to testify.
Okay. All right. And Mr. Gilbert, that's consistent with your conversations with them?
It is just conversations prior to the trial beginning and also at lunch.
Okay. So what we'll plan to do then is bring the jury out. Are you intending any rebuttal witnesses?
No, yeah.
Okay. So what I'll do is if something changes, then you're going to have to interject to approach or stop me. But what I'll do, otherwise, we'll bring the jury out. I'll say Mr. Gilbert, and then you can say you're calling your client to the stand. We'll take his testimony. If you rest, we'll go directly into closing arguments and instructions.
Thank you.
Okay, ready for the jury then?
We are.
All right.
All right, please be seated. All right, it's always nice to see the same number of jurors return after lunch, so thank you, so that we didn't have to send out anybody searching after you. Mr. Gilbert?
Yes, I'd like to just call one witness, Your Honor. I'd like to call William Rapson.
Okay. Mr. Rapson, you want to come on to the witness stand, please? Raise your right hand for me, Mr. Rapson. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can have a seat.
You can see. Can you hear me okay?
Yes,
Okay. Sir, can you state your name for the record, please? Can you state your name for me, please?
William Arthur Rapson,
Okay. And where do you currently reside?
North Country Motel.
Okay. All right. And do you know why you're here today, Mr. Rapson?
Yes,
Okay. And there was an incident back in August of 30th of 2024. Do you remember that?
yes.
And can you tell us what happened that day?
I was driving down the road and these two dogs come running out of a little wooded area there towards the truck. I swerved to miss them, but I bumped one of them with my bumper.
Okay. Did you see what happened to the dog after you hit the dog?
The dog got up and then the owner showed up. So he ran to his owner.
Okay. And so did you intentionally try to hit that dog that day?
No,
Okay. And what were you doing at the far end of that road, the dead end road that you live on?
I got or had a bait pile
Okay.
in my backyard and I heard a gunshot.
Okay.
That's what made me go down there.
Okay. Well, you heard audio today. Why did you tell the deputies that you weren't driving that day?
I don't know.
Okay. Do you remember telling the deputies that?
No, I don't.
Okay. But do you remember the deputies looking over your vehicle?
Yes,
Okay. In your garage?
yes.
Okay. Now, do you get along with the dog's owner?
I thought we got along, yes.
Okay. Also, we heard testimony today about poisoned meat by your house?
That I don't know anything about any meat
When was the first time you heard about this poisoned meat?
today.
Okay. And again, you're telling this jury that you did not intentionally hit that dog,
Not intentionally, no,
but you did hit the dog.
but I did hit him, yes.
Okay. Now, do you dislike these dogs for any reason?
No,
Okay. And again, you don't remember why you told the officers that you weren't driving that day?
no, I don't.
I have no further questions. Thank you, sir.
Any cross-exam?
I speak softly sometimes, so let me know if you can't hear the question, okay?
Okay,
Okay. So after you hit Katie, what did you do next?
I continued on going home. The dog didn't appear to be, damaged, or, he wasn't waddling off with a limp or anything.
How did you know? Did you stop?
Because I stopped, yeah, when I hit him.
How long did you stop for?
Probably 10 minutes.
Did you talk to John McElroy when you stopped for 10 minutes?
Yes,
And did you talk to Gil Litzner when you stopped for 10 minutes?
no,
Did you exit your vehicle when you stopped for 10 minutes?
no.
No further question. Sorry, I have another question. Who did you tell about this version of events to? Did you tell anybody that you hit the dog?
No,
Okay, thank you. No further questions.
Can you redirect?
Just briefly. Mr. Rabson, do you remember exactly how long you stopped for? Was it 10 minutes or was it less?
between 5 and 10 minutes. It was a brief stop.
Okay.
I didn't check my watch, but it was real brief.
Okay. I have no further questions. Thank you, sir.
Any questions from the jury? You seeing none, Mr. Rabson, you can step back down to the table with Mr. Gilbert. Mr. Gilbert?
I have no further witnesses, Your Honor. Thank you. I close. I rest.
Okay. Ms. Goodrich, closing argument?
Thank you. Good afternoon, and thank you for your service here today. We tried to be respectful of your time and made this trial move along as efficient as possible. You've heard the audio recordings, you've seen the photos and medical report, you've listened to the witness's testimony, and now it's your turn to deliver justice. We know what happened on August 30th of 2024. The defendant, angry with his neighbor, deliberately used his truck as a weapon against something his neighbor loved, his dog Katie. Let's walk through what we know. For years, William Rabson has shown hostility towards his neighbor, John McElroy. And what did the neighbor, Gil Litzner, tell you? He saw the defendant's vehicle deliberately swerve off the road and head straight towards the dog. He thought he was going to find the dog in a ditch. He saw the dog's mouth bleeding. John McElroy also headed that way, watched William Rabson's vehicle swerve towards his family companion, Katie, heard the contact, heard Katie yell, and saw the blood in Katie's mouth, then watched her limp. In reaction, he threw his pocket knife at Bill Rabson's vehicle. Then we have William Rabson trying to tell Sheriff Ross and Deputy Klatsky that he didn't leave his house. He didn't drive, even after they told him, we have 2 witnesses that saw you. Here today, for the first time, he says that now he did hit the dog and that it was an accident. And he's never told anyone else except for here today. He testified here today that he stopped his car for 10 minutes, but there was no version of events by John McElroy or Gil Litzner when they gathered together after the hit occurred. In fact, Gil Litzner testified, I yelled at William Rapson, trying to find out what was going on as he drove back down the road. We also had the windshield markings consistent with John McElroy's statements that he threw his pocket knife as a reaction to his dog getting hit. The evidence shows deliberate action by William Rapson, intent, malice, a man who was angry. We could hear it in his voice as he talked about John McElroy in the audio recordings. And he chose to take his anger not with words, not with finger gestures this time, but with a vehicle weighing thousands of pounds. William Rapson drove past his house to pursue Katie. Ladies and gentlemen, this was cruelty, this was calculated, this was criminal. We've watched as you paid attention to the testimony and evidence presented at this trial. And now we ask you to return a verdict based on the evidence and the testimony that the defendant is guilty of intentionally hitting his neighbor's dog, Katie, and driving recklessly. The contact could have killed, maimed, or disfigured Katie, but fortunately Katie survived the reckless actions and decisions of William Rapson that day. Thank you again for your service.
Thank you, Mr. Gilbert.
Well, good afternoon, everyone, and also we thank you for participating today. And this was a quick trial, and basically there's not a lot in dispute here. Most importantly, Katie is fine. There was no permanent injury. Even the veterinarian was saying 4 days later she's completely functional. Everybody that witnessed this says she was fine after the incident. Our position is that this was not intentional. This was an accident, and thus would be not guilty of count one in this case. Even if you were to feel that this was intentional, does this act rise to the point in which you would kill, torture, mutilate, or maim this dog? And I would put before you, if that was the intent of my client, wouldn't he run right over the dog? That's not swerve at it, bump it, or that type thing. But again, my client is saying that he did hit the dog, but it was not by any means intentional. And then the last thing, like count two of this case, is whether or not my client was reckless when he did that. You would have to find that he was willfully and wantonly disregarding the safety of operating vehicle on that road. And on both of these counts, we'd ask you to come back with a verdict of not guilty. First, due to the fact that there wasn't any intent, and even if there was intent, it doesn't rise to a guilty version of this statute. In addition, number two, that he did not willfully and wantonly disregard safety while operating on Stony Point Road. Thank you.
Ms. Goodrich, any rebuttal argument?
Again, I would just ask you as the jury to remember the testimony that you heard, the exhibits that you viewed, and the audio recordings that you heard, and find the defendant guilty. Thank you.
All right, thank you. Well, members of the jury, the evidence and arguments in this case are finished, and I'll now instruct you on the law. That is, I'll explain the law that applies to this case. Now, different from your blue notebooks, the final instructions I'm reading you right now, I will send you into the jury room with your deliberations with 2 written copies of them in black. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You mustn't let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions but ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. Remember, we said a person accused of a crime is presumed to be innocent. This means you must start with the presumption the defendant is innocent, and this presumption continues throughout trial and entitles defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements, and the prosecutor must prove every element beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair and honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. So a reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of the facts and circumstances of the case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in the case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits and admitted into evidence, and anything else I tell you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he's charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They're only meant to help you understand the evidence in each side's legal theories. You should only accept the things the lawyers say that are supported by the evidence and by your own common sense and general knowledge. And the lawyer's questions to the witnesses are also not evidence. You should consider those questions only as they give meaning to the witness's answers. My comments, rulings, or questions and instructions are also not evidence. It's my duty to see the trial is conducted according to law and to tell you the law that applies to the case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express any personal opinion about the case. If you believe that I do have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I may have excluded evidence that was offered or stricken testimony that was heard. Don't consider those things in deciding the case. Make your decision only on the evidence I let in and nothing else. And your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you shouldn't use any personal knowledge you may have about a person, place, or event. To repeat once more, you must decide the case based only on the evidence admitted during trial. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it's raining. Facts can also be proven by indirect or circumstantial evidence. And that is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial or indirect evidence. Circumstantial evidence by itself or in combination with direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You don't have to accept or reject everything a witness said. You're free to believe all, none, or any part of anyone's testimony. And in deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on any of the protected categories we described earlier. Again, take the time you need to test what might be an automatic or instinctive judgment and reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but I'll remind you of the questions that might be helpful to ask yourselves. Was the witness able to see and hear clearly? How long were they watching or listening? Was anything else going on that might have distracted? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did they seem to be making an honest effort to tell the truth? Or did they seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge their testimony? Do they have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect their testimony? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does their testimony seem when you think about all the other evidence in the case? Now, sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think first about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with all the other evidence in the case. However, you may end up concluding that a witness deliberately lied about something that's important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You shouldn't decide this case based on which side presented more evidence or more witnesses. However, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to judge the testimony of any other witness. You've heard that a lawyer or lawyer's representative talked to one of the witnesses. There's nothing wrong with this. A lawyer or lawyer's representative may talk to a witness to find out what they know about the case or what the witness's testimony will be. So again, in count one, which is third-degree killing or torturing an animal, the defendant is charged in count one with the crime of third-degree killing or torturing an animal. To prove this charge, the prosecutor must prove the following element beyond a reasonable doubt: that the defendant committed a reckless act that the defendant knew or had reason to know would cause an animal to be killed, tortured, mutilated, maimed, or disfigured. Reckless act is defined as willful and wanton disregard for the safety of persons or property, or knowingly disregarding the possible risks to the safety of people or property. And animals are legally defined as property. Count two, reckless driving. The defendant's charged in count two with the crime of reckless driving. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant drove a motor vehicle on a highway or other place open to the public or generally accessible to motor vehicles. Second, that the defendant drove the motor vehicle in willful or wanton disregard for the safety of persons or property. Willful or wanton disregard means more than simple carelessness, but does not require proof of an intent to cause harm. It means knowingly disregarding the possible risks to the safety of people or property. And again, animals are legally defined as property. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about August 30th, 2024, within Sheboygan County. Any possible penalty should not influence your decision. If you find the defendant guilty, it would be the duty of the judge to fix the penalty within the limits provided by law. When you go to the jury room, you will be provided with written copies of the final instructions in the black notebooks. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to reach a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. Therefore, it's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and don't hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you, or just for the sake of reaching a verdict. In the end, your vote is your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or during, you may submit them in writing to the bailiff. If you want to communicate with me at all while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. So if you have any questions, knock on the door and the foreperson hands the question written down to the bailiff. When you reach a verdict, knock on the door and either give the bailiff a note that you've reached a verdict, or just tell the bailiff at that point you've reached a verdict. But do not tell the bailiff what the verdict is, and do not hand them the verdict form. We'll assemble everybody and bring you back in, and the foreperson should bring the verdict form with you into the courtroom folded in half. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the exhibits that have been admitted, just send a note out asking for them. And when you go to the jury room, you will be given a written copy of the instructions you've just heard. As you discuss the case, you should think about my instructions together as the law you are to follow. The defendant's charged with 2 counts. That's the crime of third-degree killing or torturing an animal and reckless driving. These are separate crimes, and the prosecutor is charging that the defendant committed both of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all, any one, or both of these crimes, or not guilty. And I'll send you back also with 1 copy of a verdict form. It has the case caption. It says verdict form. You may return only 1 verdict on each count. Mark only 1 box for each count. And then there's count 1 with a box for not guilty and a box for guilty. Count 2, the same. So once you reach a unanimous verdict, you would check the appropriate box, and the foreperson would sign and date the form, fold it once in half, knock on the door, and tell the bailiff that you've reached a verdict. All right, now, thankfully, nothing happened in the lives of any of the 13 of you here today. At this point, as I described earlier, we're going to select one of you to be excused as an alternate. If that's you, sometimes the alternate is relieved that they don't have to deliberate. Other times they are disappointed that they don't have to deliberate. Whichever the case is, I want to assure you that your presence is vital to provide the constitutional right to a jury trial. And we many times do have to rely on the use of an alternate. If you are excused, then you'll be welcome to either stick around in the gallery if you wish, or you can go home, whatever you want to do, and you'd be free to talk with anyone about the case, with the exception of any of the jurors who are still sworn as a jury, of course. All right, so at this point, I'll have the clerk randomly select our alternate.
Number 47, Deborah Marie Fuller.
Right, and that is in seat 10. Ms. Fuller, thank you for your service. Do you have anything in the jury room?
No, I do not.
Okay, so you can exit right out that door. And
I'm gonna say, wow.
okay.
Go over. You look like you were gonna go over.
All right.
See ya.
All right, so if you want to go, you can slide right out the door right behind you.
Oh, I'm gonna sit right here.
I know, but can you go right out the door right behind you
Oh, okay,
and then enter through the gallery doors?
okay.
Okay. All right, and then at this point, I will have the clerk swear the bailiff.
Stated the deliberation for the verdict they have agreed upon.
All right, so at this point, the bailiff is going to show you back into the jury room and he's going to give you the 2 black binders and the 1 verdict form.
All rise.
Obviously, I did not read and I removed from the notebook the instruction 3.3 for defendant not testifying. Ms. Goodrich, are the people satisfied with the instructions as given?
Yes, Your Honor.
Mr. Gilbert, the
Oh, yeah,
defense?
thank you.
If the jury sends out a note requesting an exhibit that by its note is just one of the photographs, do you want me to just send it back without convening counsel to consult about it?
No objection to
That'd
that.
be fine.
Okay, if they ask for one of the recordings, we'll come back and talk about how we're going to do that. All right, any other issues to put on the record from the people,
No, Your Honor.
from the defense?
No, Your Honor.
Okay, so as this court's practice, make sure we've got a cell phone where we can reach counsel if the jury does have a question or reaches a verdict, so we can reassemble without delay. And Mr. Rapson, I'm going to instruct you, we had a little miscommunication as well about what happened over lunch and had to track you down again. So Mr. Rapson, I'm going to tell you, you're going to be in one of 2 places only. In this courtroom or right next to Mr. Gilbert. Okay, that's it. You are with Mr. Gilbert or you're in this courtroom. Do you have any questions for me about that?
No,
Okay, you're not to go anywhere else because we need to reassemble quickly if the jury has a question or a verdict. If we're trying to reassemble and I see Mr. Gilbert and you're not with him and you're not in the courtroom, you will go to jail. Do you understand that?
yes,
Okay. All right, we'll be in recess.
All rise.
I'm told that the jury has a verdict. Are we ready to receive the verdict, counsel?
Yes, Your Honor.
Yes, Your Honor.
Okay, we have the jury. All right, members of the jury, have you selected a 4-person to speak for you? All right, so without telling me what it is, have you reached a verdict?
Yes.
Okay, would you please hand the verdict form to the bailiff? All right, Madam 4-person, would you please stand and announce your verdict into the record?
Yes. On count 1, 3rd-degree killing or torturing of an animal, we find the defendant guilty. Count 2, reckless driving, we find the defendant guilty.
Okay, and could you hand the verdict form back to the bailiff, please? Mr. Gilbert, would the defense like the jury polled?
No, thank you.
Okay. All right, well, members of the jury, thank you for your service today. You're excused in this matter and will be free to speak with anybody that you wish about the case. At this point, I'm going to have the bailiff show you back into the jury room and I have to take care of something very quickly on the record. And then I'd ask you to just wait around a minute or 2 and I'll be back momentarily to speak with you.
All rise.
Good. All right, defendant having been found guilty for the matter. Ms. Goodrich, do you have any motion?
Your Honor, I would ask that bond be revoked at this time since he's no longer presumed innocent. And after hearing the testimony today.
Mr. Gilbert, your response?
Obviously, we'd be opposed to that, Your Honor. Other than this morning, my client has never failed to appear for court and we'd ask that bond stay as it is.
There was a bit of an issue with this morning with what Mr. Rapson's address was. Do we have a good address for him at this time?
I believe he's at the North Country Hotel.
And Mr. Rapson, if you change your address at all, you have to let the court know that day. Do you understand?
Okay.
We were here for a jury trial this morning and you weren't. We had to send a deputy out to get you. So it's very tempting to cancel your bond right now. So you sit in jail between now and your sentencing. So I know you'll be here for the sentencing. But he did have car problems that he's explained, and that was consistent with what the deputy reported to court staff when he came back. Mr. Rapson, other than the issue with his car today and has appeared for all court proceedings. I don't know how it's going to score out. I know there is a habitual notice, but I don't know how it's going to score out or what the sentence would be. And so I don't want to prejudge that. So I'm going to continue Mr. Rapson's bond. We'll schedule it for sentencing on October 7th at 3:10 in the afternoon. Mr. Rapson, before you leave today, I want you to go across the hall to the probation department, tell them you were just found guilty and they need to prepare and you need to schedule an interview so they can write a report for me about what the recommended sentence would be. You have to cooperate with that, okay? Do you have any questions
Okay.
about that? All right, anything further from the people?
Your Honor, can Mr. Rapson be instructed that his behavior between now and sentencing would be considered at sentencing, so there's no retaliation against the witnesses testified, that testified?
Oh, yeah, so is there already a no contact provision?
Yes.
Okay, so there's a no contact provision with you and, Mr. McElroy.
Right,
Don't do anything to upset that.
no,
Okay. If you do anything like that between now and the sentencing, the sentencing would be a very bad day for you. You understand me? On October 7th, I'm going to decide if you go to jail or not, but for how long. So don't give me reasons that I don't already have.
okay.
Okay. Anything further from the defense?
No, Your Honor, thank you.